welcome back to Consider This. Melisa and Sharaad here with you. Now, earlier today, the MACC revealed a series of 9 audio recordings of high-ranking officials, including former Prime Minister Datuk Seri Najib Razak, alleging that there was a, quote, criminal conspiracy at the highest level, unquote. To discuss this further, we have joining us on the line Syahredzan Johan, civil liberties lawyer. Thank you for joining us this evening, Shah. Now, my first question to you is a comment that the MACC Chief Latifah Koya said. She said that the recordings were revealed to the media and to the public because it concerned an issue of public interest. Now, in your opinion, do you think that the MACC should have played these recordings so publicly? Could it affect perhaps the ongoing trial?
I think in terms of affecting the ongoing trials, I think we must look at the recordings. And if we listen to those recordings, it would appear that they are recordings of things which happen after the fact, meaning after, whatever alleged crime has occurred, and, this is the fallout to those events. So as far as I'm concerned, what is happening right now, or the charges right now, are relating to the alleged crime itself. So I don't think that any of these recordings would actually interfere with the ongoing trials as it stands right now. They may, however, reveal, if the public prosecutor feels that there's something there, but they may reveal new offences of which those involved can be charged with. As for whether
please go ahead.
It should be revealed, I think I agree completely with Latifah, because when it comes to something which is in the public interest, the public needs to know. And we have actually seen MACC having press conferences updating about what they have done and what they have discovered and so on and so forth. So this is nothing extraordinary. It's just perhaps the substance is shocking and caused quite a stir. But in terms of actually updating the public, I don't see anything wrong with what MACC has done.
Sure, there's a question, and this is an expression, a legal expression that's bandied about perhaps a little too freely, sub judice. There's people saying that this they've characterized what the MACC has done as sub judice. What's your opinion on that?
I disagree. I think I think we must remember that when you talk about sub judice, it's something which will interfere with the trial. Now, in Malaysia, we don't have jury trials. We have judges deciding, and judges decide based on the evidence presented in court. So I don't see how these recordings which were played in public would have any impact on the trial itself. That's number one. Number two, as I mentioned, these are recordings which appear to have been made after the alleged crime has occurred, after the, supposedly 1MDB monies were stolen or SRC monies and all these things. So it seems to be about the fallout of the controversy that has erupted. So I don't think any of these recordings would be of use either for the prosecution or for the defense for the ongoing trials.
Right.
Again, they may reveal new charges, and that's something completely separate.
Shah, I take it like us, you two have been, riveted by the 9 audio recordings. Now, in your opinion, which part was the most damning, or potentially most damning?
I think there has been instances in these recordings where, someone who is purportedly the former MACC chief, Zulkifli, who was revealing to Datuk Seri Najib about the investigation papers and so on and so forth. And I don't think that is proper. I think that is a clear instance of an interference with the administration of justice. And also, of course, there's also talk, which the recording which you have played, about, trying to make it appear to the Department of Justice in the US that there's nothing wrong with the monies are legitimate to show that there's no money laundering or whatever. And I think this relates to the investigations in the US. So these are things which to me appear raises question about whether crimes have been committed. we don't know whether, how they were obtained and so on and so forth. So we have to put that aside. But, if you ask my personal opinion, hearing the recording, those would be the ones which may reveal certain improprieties at play.
Sure. Speaking of the question of how they were obtained, is that crucial to the use of this as evidence? If, say, new charges are filed and this is preferred as evidence, will the nature of the recordings, who did it, when it was done, so on and so forth, matter?
Not really, because unless there is a specific prohibition, generally evidence which were obtained, without the knowledge of the other person is admissible in court. And of course, the burden is on the prosecution to basically prove how they were obtained, who recorded it, and so on and so forth. And this is a burden that is not easily discharged by the prosecution, especially if it is done anonymously. They need to be able to identify that, the people who in those recordings are actually people who are named. But although it does appear that Datuk Najib himself has basically confirmed that some of the recordings are genuine, because he seems to have responded to some of it as if they are real. But at the end of the day, it requires the public prosecutor to prove that these recordings were obtained. So it's not a matter of the recording need to be obtained in a legal manner. It's a matter of proving that the recordings were indeed recording about these phone conversations.
Right. Shah, you've also commented publicly that it's not only legal for the Malaysian government to tap phone conversations, but it was also Najib Razak's administration that made it so. Could you elaborate a little bit on the law surrounding phone tapping, the circumstances that allow for it?
Okay. If we look at Section 116C of the Criminal Procedure Code, it allows the public prosecutor to basically authorize the police to intercept, listen, or record any conversation by communication if the public prosecutor considers that information likely contains information relating to the commission of an offence. And Section 116C also provides that such information, if it is obtained through this manner, is also admissible in court. This is the general sort of power given to the police. Whether this was the case in terms of the recordings, I do not know, because, again, we do not know how the recordings were made. Whether there was any authorization by the public prosecutor for it to fall under the ambit of 116C, we're not sure. So to say that, in this particular instance, it falls under 116C, it's at this point we can't say that conclusively. But yes, as a general rule, the police do have these powers, and that's why I say it's been ironic, because it was Najib's administration which introduced these powers to the police. Before this, it was only the MACC who had such powers. Under the MACC Act, they had powers to basically intercept communication. But Najib's administration in 2012 widened the power to give police the power for any offence, regardless of whether it's under the MACC Act or any criminal offence at all. So to me, it is ironic that now, you have a situation where the former Prime Minister had his phone basically tapped while he was a sitting Prime Minister, and now we're seeing it. So the administration which allowed the police to legally spy on you, the head of it has now been revealed to have been the so-called victim of phone tapping.
Right. Ironic indeed. Thank you so much for speaking with us tonight, Shah. We'll be back with more on Consider This. Stay tuned.